Can a country legally use nuclear weapons? Let's explore what international law says about the most powerful and most controversial weapons on Earth. Article 2.4 of the UN Charter prohibits the threat or use of force in international relations. But there is one key exception. Article 51. The right to self-defense if an armed attack occurs. But does that include nuclear weapons? That remains legally undefined. The key legal question: is a nuclear response proportionate under international law? The International Court of Justice gave its opinion in 1996 on the threat or use of nuclear weapons. The court did not say whether nuclear weapons are legal or illegal in extreme cases of self-defense. The question is still legally unresolved. However, the court confirmed that total destruction of civilian populations goes against international humanitarian law. Who has the right to nuclear weapons? International law recognizes 5 nuclear-armed states under the Nuclear Non-Proliferation Treaty. They are the United States, Russia, the United Kingdom, France, and China. These countries are allowed to possess nuclear weapons, but they are also obligated not to spread them to others and pursue disarmament over time. But other countries like India, Pakistan, North Korea, and likely Israel also have nuclear weapons, though they are not recognized under the treaty. International humanitarian law sets clear limits, even in war. 3 core principles must always be respected: distinction between civilians and combatants, proportionality, attacks must not cause excessive harm, and the prohibition of unnecessary suffering, especially from weapons that cause long-term agony. These principles challenge the legality of using nuclear weapons in any scenario. Here's the key issue. It's nearly impossible to use nuclear weapons without violating at least one principle of humanitarian law, whether it's distinction, proportionality, or the ban on unnecessary suffering. Nuclear strikes almost always cross a legal red line. Nuclear weapons are largely incompatible with the core rules of humanitarian law. The bombings of Hiroshima and Nagasaki are powerful examples, causing long-term harm to civilian populations that lasted for decades. The bombings of Hiroshima and Nagasaki killed over 200,000 people, most of them civilians. Around 140,000 died in Hiroshima and 70,000 in Nagasaki by the end of 1945. But the damage didn't end there. Radiation exposure caused cancer, birth defects, and lifelong suffering. Nature, too, was affected, with poisoned soil, contaminated water, and long-term harm to local ecosystems. These tragedies show why nuclear weapons are not just a military issue. They are a humanitarian and environmental disaster. Here's the legal gap. Deterrence strategies are political, not legal. The first strike doctrine is not regulated by international law. The United States does not rule out a first strike. China officially commits to a no first use policy. Russia allows nuclear use if the survival of the state is in danger. Gaps and threats remain. The problem is, international law does not impose a complete ban on the use of nuclear weapons. A state can claim self-defense, and it's hard to prove abuse. But who decides what's legal? Only the UN Security Council, and its veto power often blocks real accountability. There is no clear international rule that completely bans the use of nuclear weapons. However, most legal instruments aim for a total ban, and in reality, any use would almost certainly violate humanitarian law. So, while nuclear weapons may be legally allowed in theory, in practice, their use is nearly impossible to justify. Enjoy your progress. You're improving every step of the way. New legal English videos are coming soon. So hit that subscribe button and don't forget to like the video.